All right, it is now 1 o'clock, so we'll go ahead and get started. Welcome to the third edition of the ATCP 72 Rule Revision Advisory Committee. For anyone in attendance for their first time, my name is Ted Dahlsky. I'm the Environmental Health Technical Specialist for the lodging programs at DACCAP. Today's agenda, we'll start with roll call, as we always do, as followed by the public appearances, in case there's anyone from the public that would like to speak. From there, we'll just take a quick look at a new webpage we created to house all of our documents, those that we've been working on, the minutes, and then also previous agendas. And then from there, we'll get right into the code. We're looking at subchapter 1 today. We'll finish that up. We did work a little bit on it already, with section 3 being the definitions that was covered in our October meeting. So we'll look at section 1 and 2. And then subchapter 2, we have section 4 through 8 to touch on with fees. We won't actually get into numbers for fees this time. This will kind of overlap with our January meeting. We'll get more into in depth with that. As a reminder, our December meeting has been canceled, and after the conclusion of this meeting, we'll pick back up in January. So with that, we'll go with roll call. Obviously, I am here. Greg? Amy? See Amy on there. Chrissy?
I'm here. Hello.
Hi. Lori? Emily?
Here.
Melissa?
Here.
Brandon?
I'm here.
Oh, hi, Brandon. Corey?
Here.
Craig?
Here.
Jason? Jim?
Yep.
Jason again, Hager? Trista?
I'm here.
Bill?
Here.
Andy? Jumani? And Dave. And then additional attendees, Andrea?
Here.
Reed?
Here.
And Mary Ellen.
Here.
And then is there anyone else on the call that was not already named? Looks like we have
Dave Bond.
Dave. Okay. Hi, Dave.
I didn't know
Brian
that was the Dave you
Becker,
called
Sawyer
before.
County.
Go ahead. What was that, Dave?
I didn't know if that was the Dave you called before.
Oh, yes, it was. Sorry. I see you're on your phone. You might
Yep,
have
I'm here.
a visual on it. Thank you. Okay. Brian
Right.
from Sawyer.
Yep.
Okay. And it looks like we might have Matt McKay on as well from Sawyer as well. Thank you. And it looks like Linda, you're joining us again from last time. I got a thumbs up there. Okay, thank you. Any public appearances? Andrea, had anyone registered with you ahead of time?
No, they did not.
Okay. And hearing no one else from the public, so we'll move on from there. On to the web page that we added to our DACCAP homepage. I'd like to thank Linda for bringing it to our attention, and I think a couple other people may have mentioned that it would be nice to have these materials housed somewhere. So we went ahead and did that from our main web page. So that would be daccap.wi.gov. You will land on this this homepage. So I create a little video here on how to move or navigate to our area. So under program and services, scroll down to food and recreational safety. From there to recreational facilities.
Ed,
Yep,
are you showing something on your screen? Because I don't see anything.
there should be a little video moving through.
Nope, there's nothing.
Oh,
I can see it.
Same here.
Yeah, I can see it on my end as well.
All
Same
right,
here.
I'll log out and log back on.
okay. We'll see you soon.
Yep.
But anyways, going into recreational facilities, you can choose either hotel, motel, or tourist rooming house. Either one of those pages will take you on the right bar under state laws is the Rural Revision Advisory Committee link. So if you click on that, it'll take you to this landing page, which we will then put the meeting notices, the minutes, The recordings and any materials that are used for each meeting, we'll have these posted at the conclusion of that. They do have to be reviewed by our public information officer, so it may be a little bit of a delay, but I hope to have that up within a week of each meeting. We are still doing the public notices as required. The agenda and public meeting notice is on the public meetings website, and that is publicmeetings.wy.gov. I've been trying to get those up there at least 2 weeks in advance. They are required to be up within 24 hours of the meeting, so they have been up there so far, and we will continue to do that. But for any materials that have been used, you can find them here on this webpage. All right, moving forward to our code review timeline, I kind of want to put together a big picture of the code and when we will plan to get to certain sections. So far, obviously, we covered in our October meeting, that's section 3, which is the definitions. Today, we're doing the 7 highlighted sections: authority and purpose, scope of rules, license holder qualifications and responsibilities, plan review, licenses, and then department fees. And then in our January meeting, we'll finish up department fees as well as the subchapter 3 and 4, and we will carry on 5 in the subsequent meetings. So I just wanted to give a bigger picture there in case there's something you wanted to be involved with in the future. You can tune in those specific months. That's the anticipated time we will discuss them. And with that, we will move on to our code language. So let me stop sharing this and share the other document. All right, is that okay for size for everyone? Do you need to zoom in at all?
Looks good.
Okay,
Works for
thank
me.
you. All right, so we're starting with subchapter 1 here, definitions, authority, and purpose. 72.01, authority and purpose. This chapter is promulgated under the authority of State Statute 97 and 227 to prescribe rules for hotels, motels, and tourist rooming houses for enforcement by the department and its agent to protect public health and safety. So I went ahead and paraphrased each of those sections, 605, 607, etc. So that is covering lodging and vending licenses, pre-licensing inspection, fees, agent status for the local health department, health and safety standard, powers of the department and local health departments, hotel rates posted, enforcement, and agency rulemaking authority. I did make a comment here to propose removing 638, which is hotel rates posted or rate charges special rates. So it covers the maximum room rate that a hotel would charge, and also if there's a phone rate, a charge for using the phone, such as like a long distance call or something like that. I'm proposing removing the 638 because it is a consumer protection and not necessarily a public health and safety clause. Are there any objections to doing that?
Only that it is still a statutory requirement under 97.
And
That's the only reason why I included it.
that's the one thing I have in here is that it has for both the room rate and the phone rate that we may enforce, or the department may inspect hotels to ensure compliance, but it does not use shall or must.
Yep.
Is
So-
it possible to make a note, Ted?
Sure.
Add it as a note possibly,
Okay.
just so people
That
are
way we
aware.
won't lose it. Okay. I know many places are moving away from phones too in general, so I feel like it's somewhat obsolete. I also wanted to point out 605 here. So there were 2 bills that came through, Assembly Bill 709 and Senate Bill 665. One came out yesterday and the other one a few weeks ago. But it is amending state statute 66, which really has nothing to do with us. It doesn't affect DACAP and this particular rule. But it is proposing to create 97-605-1G, which would have an impact on our rule and our enforcement. So just to summarize, this bill prohibits a person from conducting, maintaining, managing, or operating a tourist rooming house for more than 90 days in a year. And it is proposing to create this 97-605 1G, no person may conduct, maintain, manage, or operate a tourist rooming house for more than 90 days in a year. Right now it is in proposal, it was read in and referred to committees in both the Senate and the Assembly. So it still has more action to occur before it does become law, if it even does. But if you are strongly in favor or strongly against, I suggest you reach out to those committee members and voice your opinion regarding this. But this would have an impact on our rule if it were to pass. So just wanted to bring that to your attention.
So Dad, you said that was just done recently?
Yeah, so let's see here, let me bring my window over.
It's in 66 currently, which limits it to 180 days. And
Yep.
there's no mention of it in 97.
Mm.
But with this recent change, it would cut the 180 days down to 90 days.
Right
And
here.
it would put it also in 97 as well as 66.
So it would put in 97 as 90 days.
Yes.
Correct.
Okay.
From my conversations at the Capitol, it sounds like they're not planning on this actually going anywhere this session, but they're getting it out there for future consideration. That's what I've been hearing anyway.
Okay, thank you. That was Bill.
Thank you.
Yep, that was me.
Okay, thanks, Bill. And to answer your question, so the Assembly Bill 709 was introduced yesterday, and the Senate bill was introduced on the 9th.
Okay, thank you.
You're welcome. Okay, so we are on to 72.02 scope. Number 1, applicability. This chapter applies to the operator of any hotel, motel, or tourist rooming house and to the department and its agent. Just putting in our lodging facility to condense that. Number 2, variances. When it appears to the department that strict adherence to a provision of this chapter is impractical for a hotel, motel, or tourist rooming house, the department may approve a variance from that provision requested by that hotel, motel, or tourist rooming house operator if the operator provides the department with satisfactory proof that the approval of the variance will not jeopardize the public's health, safety, or welfare. I'm going to do this ahead of time next. The reoccurring theme. Okay, number 3, procedure for a variance request. A, application. Request for modification or waiver of a requirement of this chapter shall be submitted in writing to the department or its agent having jurisdiction along with documentation specified in paragraph D. B, local review. A local inspector shall review the request and forward it to the department with the recommendations for approval or disapproval. C, department action on a variance. On receipt of a complete variance request as specified in this section, the department shall review the request and grant or deny the request in writing within 30 working days. A variance approved by the department shall be made conditional for a defined period of time or shall expire 5 years from the date of issuance. The department or its agent shall maintain a copy of the variance in the establishment's inspection history file. Jim, have we done variances other than 5 years?
We've done some experimentals with less than 5 years.
Okay, I haven't been involved with that, so I just usually the
Sometimes,
5
Ted,
years is
they-
the default.
Yeah, sometimes they, like, a construction project's gonna be done in 18 months, and so they go for 18 months or something like that.
Okay, sure.
And Jim mentioned experimental. Is that language in this rule at some point?
It is
Well,
not.
And we don't, we can call it an experimental variance and have less than a 5-year period on there. But it's still a variance.
Thanks, Jim.
Does anyone need clarification on what a variance is? Okay.
Do you have to be a license holder before you can apply for a variance? Or can you
Um,
read the code and decide, okay, my place isn't
Yeah,
gonna pass?
right.
And have a formal variance approved before you
We-
apply?
We have approved them in the past, so I'm thinking in the campground realm, when someone's using an alternate dump station, you know, they know they meet the requirements to be granted one. They will submit that at time of plan review application and before the pre-inspection is conducted, and we've gone and approved those with a pending license ID. So I know in the past we have approved for someone that is not a license holder yet.
Okay.
Because-
Does it say license holder? In the, if you scroll up to the where it says you can apply for a variance?
An
No, it doesn't.
operator.
Yeah,
No, yeah.
okay.
Sometimes you get caught with this chicken or the egg though. You know, your operation won't work unless you get an approved variance, and you need an approved variance. You know, we don't want you to be required to be a license holder at that point, I guess. You could get kind of stuck in the middle in some of those situations. But no, it just says an operator here. D, application contents, documentation justifying a proposed variance from the requirements of this chapter shall include the following. 1, a statement of the proposed variance from this chapter requirement citing relevant chapter location numbers. 2, the rationale for how the potential public health hazard and nuisances addressed by the relevant chapter section will be alternatively addressed by the proposed variance. 4, conformance with an approved variance. If the department grants a variance as specified in sub 2, the license holder shall meet all of the following requirements. A, conditions. Comply with the department's conditions for the variance approval. B, records. Maintain a copy of the approved variance at the hotel, motel, or tourist rooming house. 5, transferability. An approved variance is not transferable to any other hotel, motel, or tourist rooming house entity or licensee. Reissuance. A, request. A license holder who wishes to continue a variance after its expiration shall file a request with the department for reissuance of a variance at least 30 days prior to its expiration, unless permission for a later date has been granted by the department. B, status of existing variance. When a license holder has made timely and sufficient application for the reissuance of a variance in reference to any activity of a continuing nature, the existing variance does not expire until the application has been finally acted upon by the department.
So would that come into play if there's a sale? I mean, do we need to address that specifically, or are we making the new owner of said lodging facility go through this process again?
Yes.
Okay.
What that section is referring to is if an existing operator is reapplying for the extension of the variance and it takes the department longer than it does before it expires, his existing variance is still in place until the department takes its final action.
Correct.
Yeah, coverage.
Understood. Okay.
Do we want to add to that transferability section, except in the case of an approved license transfer? And then under whatever section that's going to be in.
Sure. Craig is making mention to you can make a transfer to a family member if there's someone in an LLC and it gets bought out by a person of that original LLC who is the owner, they can take ownership to. There's, I think we might actually cover it today, but there's sections on approved transfers. So that would cover that with that cross-reference. And then in our note, to obtain a form for requesting a variance, email the rec mailbox or contact the bureau at that phone number or address. Do we know if this phone number is accurate?
We probably need to check.
Okay.
Anytime, we probably always have to check.
We'll give them a ring. See where we end up. Okay, 72, we already covered definitions, but in our creation of code, Jim and I added 2 more definitions. So I think now we top 100. But we have temperature measuring device has the meaning given in the food code, and then time and temperature control for food safety, TCS, has the meaning given in the food code. And I went ahead and put those here already. So for the temperature measuring device, it means a thermometer, a thermocouple, thermistor, or other device that indicates the temperature of food, air, or water. So really what we're shooting at is a thermometer here. And a TCS means a food that requires time or temperature control for safety to limit pathogenic organisms, or let me reread. Requires time, temperature control for safety to limit pathogenic microorganism growth or toxin formation. So in other words, that would be something that requires refrigeration or requires to be hot held to a certain temperature. Right, subchapter 2, licensing and fees. 72.04, license holder qualifications. To qualify for holding a license, an applicant shall do all of the following. 1, license holder. Be the entity that is legally responsible for the operation of a lodging facility. 2, payment of fees. Pay the applicable license fees at the time the application is submitted. I do have a question, I guess, for Jim, maybe your perspective, but I occasionally get questions where someone is renting out a vacation home, or at that point, it's not a vacation home. They're renting out a house, and then they decide to take out a license on their behalf, the renter, and create a vacation home out of it.
So arbitrage.
What was that?
It's the term's called arbitrage, isn't it?
Okay.
Yeah. It's becoming more common.
Is it okay?
Yes. So if someone owns a property and a renter comes in and says, hey, I'm going to rent your vacation home or your condo or your whatever for a year, and then they turn around and then rent that out on vacation rental home sites, the term is called arbitrage.
Okay.
So some condo associations and rental management agreements prohibit it, obviously for a lot of reasons.
Right.
So keep in mind, a lot of people are doing this, but not admitting that they're doing it. So obviously those of us in the lodging industry who have hotels, motels, or condos or vacation rental homes, I can only speak for my opinion. It's not a preferable action, and we highly, highly, highly recommend against it. But
Mhm.
there's also very little we can do to stop people from it. I've had people try to claim discrimination. I've had all the things in the book thrown at us for this type of scenario, but it is becoming more and more common. And we actually now have had people approach us straight up from like a realtor relationship saying we have people looking for arbitrage style options. So it is something that I think should certainly be addressed because, again, if the owner of that property is going to be held liable, how are we to hold that person to the same standard if we don't even know they're doing it?
Right.
So it's a very
But
tricky
if it's,
scenario.
can I add something?
Yeah. Yeah. Who's this?
This is Dave Bond.
Okay, Dave.
From an owner standpoint, and I don't arbitrage, but from an owner standpoint, if it isn't prohibited by a condo association or some other restrictive covenant of a subdivision, if the owner is okay leasing a long-term lease to someone who's then going to arbitrage it on a short-term basis, why is that not preferable to you? It's legal, so it becomes an opinion at that point. So if everyone's upfront about it and okay with it, I don't see how it's any different than my LLC leases my own property from us. So we own our properties personally. Our LLC that runs vacation rentals leases it from us and runs it as a short-term rental. Our
Yeah,
license is held.
Yeah, I don't
So
think
I guess
yeah, Dave, I don't think we have a problem with it. What we're looking for is who's the person legally responsible for the TRH operation. If this is something that the owner wants to prohibit, that should be very clear in their contract. And if that person is violating their contract, that's really a legal issue between the renter and the owner.
Correct. That's how
Right,
we handle it
I
as
agree.
well.
And maybe I misunderstood what you were saying. I'm not sure who was speaking originally, but it sounded as though the whole idea of arbitrage was frowned upon and should be scrutinized. And I think that illegal arbitrage should be, but if it's an agreement, you know, the reason that it's growing in popularity is it's a very good arrangement for a lot of long-term rental owners. It gives them
And
security. So,
Dave, this is Chrissy from Wisconsin Dells. I should have prefaced that statement. Yes, illegal arbitrage is a nightmare.
right.
Very rare do we get someone who, and I guess I'll make some assumptions in this comment. Very rare do we get an honest arbitrage seeker. And it's also rare that we find that someone is upfront with us about arbitraging a scenario. A lot of the times we're finding out after the fact that they've been renting out. And unfortunately, that then involves the guest who is typically renting that unit who doesn't know it's arbitrage. So then an owner, and I'm very similar to you, Dave, where I have the same setup you do, LLCs owned personally by us. We also have managed units that we don't own. And I think whomever mentioned that, yes, it absolutely should be stated inside whatever agreement you have with whomever's either a tenant or how that works. But I think to answer this specific scenario, what's frustrating is if that owner is held responsible and an illegal arbitrage situation is brought forth, how is the owner held responsible if we don't even know it's happening?
Right.
Right.
Yeah, and I just want to make sure that we're not throwing the baby out with the bathwater again when we're kind of putting all of one category in because of the bad players in the industry. You know, there's really good people out there doing arbitrage legally, and it's a win-win for everybody. So, and I agree, illegal arbitrage, just like illegal short-term rentals, should be dealt with. But you know, arbitrage in itself shouldn't be cast aside.
Right,
Okay.
and
Correct,
we don't hold the owner of the property liable. We hold the license holder. So But that doesn't mean if something bad happens that the owner's not going to be
Put
named.
the bill for it, yeah.
Yep, and that's why you want to make sure you have a very clear contract.
Yep, absolutely.
Well, that was good discussion. So I take it a prohibit on arbitrage should not be in here based on that discussion. So that's good. We are now on to 72.05 license holder responsibilities. Upon acceptance of the license issued by the department or its agent, the license holder shall do all the following in order to retain the license. 1, access. Allow an authorized representative of the department or its agent access to the hotel, motel, or tourist rooming house and provide any required information to that authorized representative. Supposed to be enough. 2, compliance. Comply with the provisions of this chapter. 3, reporting. Follow reporting requirements to the department or its agent as applicable as outlined in this chapter. Is 3 not redundant to 2? If we're requiring reporting in the chapter, wouldn't that just be compliance with the provisions of the chapter?
It's just adding clarification. We
Okay.
can take it out if you want, it doesn't
No,
matter.
no, that's fine. Just seeing if there's a reason why it was called out. 4, operations. Immediately discontinue operations directly related to an imminent health hazard and notify the department or its agent. Replacement. Replace existing facilities and equipment that no longer comply with the criteria set forth in this chapter. Corrective actions. Comply with directives of the department or its agent, including meeting deadlines for taking corrective actions specified in inspection reports, notices, orders, warnings, and other directives issued by the department or its agent for the license holder's hotel, motel, or tourist rooming house, or in response to community emergencies. To go back up to 4, do we need to change this to a priority or define imminent health hazard?
I thought we defined it. Or did
I'm
we
looking
find it,
through.
or did we define immediate danger to health?
Imminent health, okay, means a condition that presents a substantial likelihood to cause severe adverse health consequences or death. So we do have it in there.
Yep.
Okay. 7, notices. Accept notices issued and served by the department or its agent according to law. 8, penalties. Be subject to administrative, civil, injunctive, and civil criminal remedies authorized in law for failure to comply with this chapter. 7206, plan review. The department or its agent may require a plan review for a lodging facility that has submitted an application for a license or has made alterations to an existing lodging facility. Note, in addition, a person should consult with other agencies that may also require prior plan or construction approval, such as the Wisconsin Department of Safety and Professional Services, the Wisconsin Department of Natural Resources, or the local building and zoning agency before commencing construction or modification of a hotel, motel, or tourist rooming house. (72.07) licenses. Number 1, license required. A, conditions requiring a license. Except as specified in C, no person may operate a lodging facility without holding a license from the department or its agent. The following requirements apply. 1, a separate license is required for each hotel, motel, or tourist rooming house. 2, except as provided under subdivision 3, if a license holder sells or otherwise transfers ownership of operation or operation of a hotel, motel, or tourist rooming house to another person, a new license is required pursuant to 97-605-1A. And the hotel, motel, or tourist rooming house may not be open to the public until the department or its agent issues a new license.
Is this separate license required for each tourist rooming house? Changing the fact that we allow multiple tourist rooming houses under one license if they're on the same parcel or adjacent parcels?
That is a good question. We've had that discussion, Jim and I. It's in statute. Am I correct in saying that, Jim?
Yes,
This portion here.
Gotcha. So it's,
but it also, there is a way in how it's defined in statute, which also allows us to consider what's on that parcel or property, to only issue one license. So we're grappling with defining, having a better definition for what premise means. And so when you look at statutory definitions, it all talks about the building and related structures. And so we've taken that to mean that if there are other buildings that are also being operated, we're including all of that under one license. So it's just making sure we clearly define and explain what we mean when we talk about premise.
So
and easy-
also,
Yep. Go
this
ahead.
is Chrissy again. There's
Mhm.
also on like our DATCP tourist rooming house definition page. I can share the URL if you're looking for it, but it does state under a tourist rooming house license, an operator may rent as many as 4 units. You will need a hotel license if you rent 5 or more. So would this then need to take into consideration like location? I would just think again, if we're looking at tourist rooming houses in conjunction with what the other gentleman asked prior, is like if all 4 of those are on like maybe it's a style of building that has 4 units in one address or one, they share a common space, would they then need to have a hotel license if it's different locations? I feel like there's some gray area there to understand what type of license you would need.
Yeah, 100%. There's gray area. It
Yeah.
really needs to be teased out. I brought this up in preparation. So here's a facility in the Dells. To give an idea, it's all one resort,
hmm
and we've got one lodging facility here, another lodging facility here, condo and indoor, or not condo, convention center and indoor water park. You can get from walk in this door here, walk through the entire facility and end up over here. So the discussion has been, are these separate buildings? Is it one building? And to throw a wrench in it as well, also part of the resort are what we would consider a tourist rooming house, up to 16 or so. And the idea is, how do we license these large resorts like this appropriately? Because right now, I believe this facility it tops out at the 200 plus license, but we're looking more along the lines of, I think, 700 rooms for this facility, and possibly even more, a second license to address these tourist rooming houses. So we don't have a good solution yet.
Well, and I
and
think in
we're-
this specific scenario, you also need to address the fact that ownership in these scenarios is different as well.
Correct.
So I think my question was more along the lines is, if you are maybe yes, these large properties, yes, there's absolutely some gray area there. But again, if you own 3 cabins, maybe on 3 separate locations or 3 separate parcels even, and you acquire a 4th, I think we need to have some definition to where, again, if say you're own LLC or whatever owns all 4 of these pieces of property, are you now required, if you garner that additional unit, to get a hotel license? I think how some people could think that's difficult to understand.
Right.
And I think because they don't understand it, they're just, not doing the process at all. So
Okay.
I feel like that sentence on that page, which again, if I were jumping into this, I would go to those places as a resource, as a reference, right? To say, okay, what is a tourist rooming house license? I don't know what that is.
Mhm.
And I'm not saying I don't know if this space here in 7207 is where we would address that. But again, as we take the lodging facility definition, and knowing what it is we're looking at, maybe there needs to be some further delineation about what it is you're trying to license within a tourist rooming house, especially in today's day and age, knowing that anybody can rent pretty much anything now. I'm just curious as to how we try to tackle the difference between now getting a hotel license when clearly it's not a hotel,
Right. I know. And it's, it is tough. And it used to be, if it's a 1 or 2 family dwelling, well, that's easy. That's a tourist rooming house. But like, things have changed so much. Now you've got the condo within a commercial building. I know our idea is to get away from we're stuck with 5 or more. There's nothing we can do
Sure.
with that. That's
Okay.
locked in statute, but I think our intent is to maybe have a gradient of tourist rooming houses like we do with the hotel. So you have, like in that example, you may have 16 tourist rooming houses here. You would get a adjusted license. So it'd still be 1 license, but it's now for 11 to 20 tourist rooming houses or something of that sort, I think is possibly how we're looking to go with that. And I don't know if that is the correct approach, but
Sure.
Very much so. Yes, it gets real complicated with ownership of a parcel, the ownership of the actual condo within a room, and you've got all these different players. It really muddies the water when you show up and you look at the facility. Is this a tourist rooming house or is this a hotel room? It's not well defined. I'll tell you that right now. And
I
it's
think
definitely a
that's,
question that gets asked.
that's the whole reason I think we want to separate out the tourist rooming houses from a hotel.
Sure.
Right.
The difference in inspection is much greater for a tourist rooming house than it is for a hotel, because then when I'm at the hotel, I'm really just looking at rooms. When I'm looking at a tourist rooming house, I'm looking at the whole house, basically.
Well, and your knowledge of the inspector has to be different from, again, if someone's looking at primarily, residential style facilities versus a hotel. And I mean, obviously the example on the screen is a very advanced construction, very specific as well. I mean, I think too, from the Bureau's perspective, knowing whom to inspect, how to give them guidance on what they're looking at, and then those of us who are taking the time to try to write what is that inspection requirement. I mean,
Right.
it's very specific, but I do think maybe some of those definitions on that specific, landing page of what is a tourist rooming house in a search can certainly help us guide people into understanding what the license requirement is and why it's important. Just because, again, I think those people looking, at least a lot of the people we've come across who want to seek this as a solution, I don't think they're not pursuing it because they don't want to. I think they just don't know what to do with it.
Yeah, it's very confusing the way it is now, because a tourist rooming house in the current code is just a licensing category.
Right.
And so that's why we're trying to separate that out, that a tourist rooming house is a specific thing. And that's what we're trying to tease out of this.
This
So
is Amy
hopefully-
from, oh, sorry.
Go ahead.
Oh, this is Amy from Vilas County, and we've been battling with this forever, since we've taken over the agent program. And I would say over 3/4 of our 5 to 30s fall under this category because they're old time lodging facilities, resorts, that all they are is like fishing cabins, or they're little 2-bedroom, like cabins that are not lodging hotels, but they fall into this 5 to 30 category because they have, 5 to 10 of these little fishing cabins all on the same track of property. So
Yep.
we've been, dealing with this, for the last 12 years. So I would like to see that, looked at too in the code.
Yep, that's what we're talking about, Amy, about having just a separate licensing category for tourist rooming houses, where your license is based upon the number of tourist rooming houses that you have.
Yes,
they
and then
wouldn't-
that would help us significantly. I know that you guys don't like it, but that when we get summer interns, that they can look at like some of the resorts that we have, because essentially all they are is, a tourist rooming house. They're not a commercial building, so that we could, have our summer interns look at them too.
Per the contract requirements? Is that what you're,
Yes,
okay,
because
yeah, no, that makes
because
sense.
the 5 to 30s, a lot of them that we have licensed as 5 to 30s are not commercial buildings. They're,
Right.
5 cabins.
Yep.
So
Yeah, they're probably 500 square feet, little cabins or something like that. Yeah,
yeah, yes.
yes, an intern can look at those. Yep, no,
Right.
that's good. That's good discussion, yeah.
Yes, and right now they're not allowed to because they're 5 to 30s, but really
Because
they're
they're
not any different.
hotels, right,
They're
Yep.
classified as a hotel, but they're not any different than looking at a tourist rooming house.
correct. Got it. Yeah, so that's, that's how we have been licensing them is just as Amy had said, if you hit that magic number of 5 or more on a single parcel, you get slapped with a hotel license. But they really don't, they're not hotels. So that's one of our issues that we're facing. I believe we are now on 3. Is that correct? 3. A hotel, motel, or tourist rooming house operator can transfer ownership of the hotel, motel, or tourist rooming house under any of the following. A, pursuant to State Statute 97-605 4D and E, an individual may transfer a license to an immediate family member. B, a sole proprietorship that reorganizes as a business entity as defined in State Statute 179, or a business entity that reorganizes as a sole proprietorship or a different type of business entity may transfer a license to the newly formed business entity or sole proprietorship if the hotel, motel, or tourist rooming house remains at the location for which the license was issued, and at least one individual who had an ownership interest in the sole proprietorship or business entity to which the license was issued has an ownership interest in the newly formed sole proprietorship or business entity. That's a mouthful. Okay, 4, no license issued under this chapter is transferable from one premises to another. 5, a person who wishes to transfer a license shall notify the department or its agent prior to operation of a hotel, motel, or tourist rooming house. Say 9 times out of 10, we just find out about it at time of renewal, I feel like. All right, again, to notify the department, go ahead.
Highlight the phone number on this
Yeah, okay.
again, Ed, just so we make sure we check it.
Can we put something too instead of the department, maybe, or the agent?
To notify the department or agent?
Correct.
Okay. Yeah, usually anything, if we do get something in the rec box for an agent location, we do try to forward that on.
Yep, we've gotten
To you guys.
numerous of.
Okay, good. B, pre-inspection required before the department or its agent may issue a license to operate a hotel, motel, or tourist rooming house pursuant to paragraph A and State Statute 97-607-1. The department or agent shall conduct a pre-inspection. A pre-inspection is not required for a transfer of a license under paragraph A3. Check our phone number again. Pre-inspection is, this always comes up, drives me nuts when writing things out and it comes up as misspelled. This is in other chapters, correct, Jim? Is it in 74?
Yes, it's in every chapter.
Okay. All right. C, exemptions. A lodging facility does not include: 1, a boat with sleeping accommodations located on any waterway that it is possible to float a canoe or small watercraft on a reoccurring basis.
What grammatical thing on there? Uh, where it is possible to float a canoe instead of that it is possible.
Okay. 2, a camping cabin less than 400 square feet located in a licensed campground pursuant to chapter ATCP 79. 3, a recreational vehicle. 4, overnight sleeping accommodations on a frozen waterway, i.e. ice fishing shacks. Number 2, license duration and renewal. A, expiration. Each license issued under this chapter expires on June 30th, except that a license initially issued during the period beginning on April 1st and ending on April 30th expires, or on June 30th, expires on June 30th of the following year. Like it needs an extra space, but maybe not. There's some weird formatting issue going on there. B, annual renewal. Each license shall be renewed annually as provided in subdivision 4A. 3, new license. A, application. The license applicant shall apply on an application form provided by the department or its agent. The completed application form shall be accompanied by all of the following: 1, the applicable fees pursuant to 72.08 and any fees previously due to the department or its agent under this chapter. 2, information as determined by the department or its agent, including documentation that indicates the hotel, motel, or tourist rooming house will be maintained and operated in compliance with this chapter, applicable local, federal, and state laws as it relates to the health, safety, and welfare of the public. As provided pursuant to 97.615 2D, a local health department granted agent status can establish and collect fees for licenses. If you need a license application for an agent licensed hotel, motel, or tourist rooming house, contact the local health department. We just read that, right? Oh, this is for state license, contact DACAP. E, request for pre-inspection. The operator shall contact the department or its agent and arrange a time for the pre-inspection required pursuant to sub 1B before operating a hotel, motel, or tourist rooming house. License renewal. A, payment. To renew a license, the operator shall pay the department the applicable fee specified pursuant to table A or B before the license expires. If payment to renew a license fee is not received by the department or its agent before the expiration date of the license, the late fee specified pursuant to table A or B shall be paid in addition to the license fee. Submission of an application for a renewal license is not required. B, department action on a license renewal. The department or its agent may refuse to renew a license as provided pursuant to statute 97.067 and under subparagraph 5A. The department shall refuse a renewal or to renew a license as provided pursuant to 9306 parent 7 and under subparagraph 5B. Number 5, department or agent action on a license application. A, department discretion on a license. The department or agent may not issue a new license or renew an existing license for a hotel, motel, or tourist rooming house unless all of the following conditions are met. 1, the operator has corrected a condition for which the department or agent has issued a written health or safety related order. 2, the operator, applicant, or license holder has provided the department or its agent with the information required under 3A2 or documentation indicating that the hotel, motel, or tourist rooming house is designed and constructed in accordance with state law and regulations stated in this chapter. Three, the department or its agent has determined that the operator, applicant, or license holder is not in violation of Chapter 97 or has only a minor violation as defined in State Statute 227.041A. B, license prohibited. The department or its agent shall refuse to issue a new license or renew an existing license to operate a lodging facility under any of the following conditions. 1, a fully and accurately completed, signed, and dated application has not been received by the department or its agent. 2, the department or its agent has not conducted the pre-inspection required pursuant to 72.051B. 3, the department or its agent has not approved the plan for the hotel or motel pursuant to 72.04 for which a plan was requested for review. 4, the operator has not paid all of the applicable fees pursuant to Table A or B. 5, the operator has modified, repaired, or maintained the hotel or motel or tourist rooming house in a manner that is not in accordance with this chapter.
I think these are just formatting issues when you
Yep.
transfer.
Conditional license. Except as provided in statute 93.135, the initial issuance, renewal, or continued validity of a license may be conditioned pursuant to state statute 97.605.1P upon the requirement that the license holder correct a violation of this chapter 97.625 or ordinances adopted pursuant to 97.6152G within a specified period of time. If the condition is not satisfied within the specified time or after an extension of time approved by the department or its agent, the license is void. No person may operate a lodging facility after a license has been voided. Any person who does so shall be subject to the penalties pursuant to 97.72, an injunction pursuant to 97.73, and payment of fees pursuant to 72.08. An operator whose license is voided under this paragraph may appeal the decision pursuant to 72.11. If the decision was made by the department's agent, the applicant may appeal the decision pursuant to 72.12.
Does it have to say the license is void, or could it say is either void or suspended?
This is taken from the statute, so the statute says void, but practice has been that we have the ability to do a suspension rather than voiding. It's our option, but
Okay.
statutory language says void.
Do we mention anything about a suspension, or is that in the enforcement section?
Yep, that's in the
Okay.
enforcement section.
That will be reviewed in January then. Okay.
Okay, we talked about, I don't know, maybe I missed this. What about zoning? Are we gonna require a zoning? Like, some of these areas that we cover as agents, they might be zoned differently. And I know that that's part of our application process, and they're always they're always referring to this code. Are we covering zoning? Are they zoned to do what they want to do?
We've traditionally put that on the responsibility of the person taking out the permit.
Okay,
That
so we
they
don't
would-
even
they
need
would
to
have to
mention it. I'm
contact-
just wondering.
Yeah, that they would have to contact.
But what if they don't? And you know what I'm saying? I mean, maybe we should mention the zoning in this.
Well, we do earlier up where we say
During plan
other,
review, we do.
right.
Yeah.
Oh, in plan review. Okay, I
Yeah.
just wanted to make sure.
It
I think we
is
just
in
kinda
there,
went through.
but you know, maybe it wouldn't hurt to put another note somewhere when applying for a license that you also make a connection with your local authority as well.
Because I
What
know
was
a
that?
lot of areas don't want it anymore, you know what I mean? And they're throwing up zoning stuff.
Yeah, they've been creating ordinances in addition to.
Oh yeah, maybe I'm using the wrong terminology.
Yeah, a lot of municipalities have been beefing up short-term rental ordinances that requires certain conditions, you know, like for example, I think in Lake Delton, the owner operator has to be within X amount of miles of the facility. So you don't have people potentially out of state running these. I think there's some municipalities where you have to have fire inspection or a building inspection during your initial licensing. And then from there on out, the state or agent inspection satisfies that. So there's various degrees
And-
of the ordinances.
A lot of the issues too, I think, are just becoming more prevalent because people are putting tourist rooming house licenses in residential areas. So a lot of ordinances are prohibiting those types of things if they're not zoned commercially. So I know, like, for example, like the island of Maui, right? They've banned and put some of these things on like entire areas, and then now they're, I believe, being sued over the fact that they can't have that type of ban because it's a commercial versus a residential zoning requirement. So I don't know if this document, can we have language that addresses they have to consult? I don't think we can we?
No.
Yeah, so unfortunately, I think to answer the question, and especially here in Lake Delton, they do have ordinances that talk about a manager needs to be within a certain drivable distance, and you
Okay,
can't
that's it, yep.
have, yeah, and you can't have tourist rooming houses in a residential area for stays shorter than 7 days. So
Yeah.
local municipalities can get very creative about
Yep.
what they require, but I don't think we can address that in this document, can we?
Other than a note.
No. Yeah, we
Right.
generally have the conversation with an operator. to
Mhm.
let them know that they really need to get all of their other approvals
Right.
before they get our license.
Mhm.
And if they get our license and they don't have the approval from zoning to operate, then they basically paid their fees and their license will be voided. So it behooves them to make
Mhm.
sure they have all their necessary approvals before they apply for their lodging license.
In some other items, I think that to answer, I don't know who asked the question earlier, but the people who don't, like for example, some insurance companies won't insure your tourist rooming house if you don't have a license. Some, your lender may require depending on what it is you're doing and how you're doing it. Unfortunately, I think we do have some people who like just buy cash for something. They don't need those things and are willing to kind of roll the dice. Unfortunately, that's the issue. I think we're trying to level the playing field here a little bit, but it is difficult for people who just say, I don't need any of that and I'm just going to rent it on my own, So, but I don't think we can address any of those zoning issues in this specific document, but it is frustrating that you do have some people who just don't look at any of it.
Right.
I think
And
that's why you're seeing an increased level of scrutiny
Oh,
at
yes.
the local level from zoning.
Mm-hmm.
yeah, unfortunately, our zoning representative is not on the call today, but I assume he would have had some things to chime in on there. But yes, note doesn't hurt. Somewhere again in here, in addition to the plan review, that when you're applying for a license, there's other players involved.
Yep.
The more we get that across, I think the better.
Yep.
Everyone will be. Okay, I believe we're on D now, granting or denial of a license. The department or its agent shall issue or deny a new license or shall renew an existing license for a lodging facility within 30 days after the applicant meets all of the requirements pursuant to subsections 3 or 4 as applicable. We're going to save about 4 pages of code getting rid of hotel, motel, tourist rooming house. This gets all condensed. All right, number 2, if the department or its agent denies an application for a license, the applicant shall be given the decision and reason in writing for the denial and information regarding appeal rights pursuant to 72.11. If the decision is issued by the department's agent, the applicant may appeal the decision pursuant to 72.12. Six, voided licenses for failure to pay fees. A, payment deadline. If an applicant or operator fails to pay all applicable fees, late fees, and processing charges under 72.08 within 45 days after the expiration of the license is void. B, appeal rights. An operator whose license is voided by the department under this subsection may appeal the decision as provided to 72.11, or if the license is voided by the department's agent, the operator may appeal the decision pursuant to 72.12. Pursuant to 97.6051C, the license applicant or operator shall demonstrate that all applicable fees, late fees, and processing charges have been paid. In an appeal concerning voiding of a license under this subsection, the burden is on the license applicant to show that the entire applicable fees, late fees, and processing charges have been paid. During any appeal process concerning a payment dispute, the operation of the hotel, motel, or tourist rooming house in question is considered to be an operation without a license and subject to additional fees. Would they get an operating without a license fee here, Jim?
Yes. Yep. If they continue to operate.
Yeah. Number 7, license posting. A current license issued by the department or its agent shall be posted on the premises in a place visible to the public. A license may not be altered or defaced. I did put a comment in here. I know from my days of inspecting that some operators, the licensee address is also their personal address. And they had always asked if they could, scratch off that on their license so that they weren't advertising their personal home address. I always let them do it, but what's the idea of maybe changing this sentence or removing it? Or making some allowance for modifying personal addresses. It'd still be a public record, but I don't know if anyone has a.
Oh,
I
this
mean,
is,
does
Well,
it need
the
to
a-
be?
the address of the license should be the location. If their personal address is being used, they can do that for their billing address.
Under the licensee, just make it the facility. Is that what you're saying?
Yeah, the facility address should be, who we're issuing the license to. If the owner is putting his personal address on there, then he can just indicate that as where he wants the bill sent to, and that wouldn't show up on the license. It would just
Okay.
be it would just be the facility where the facility is located. That's the address that should be on the license.
Okay, I see.
The address for billing purposes can just be a billing address, and that wouldn't show up on his license.
Basically, it'd be
billing
a
address-
health space fix.
Yeah, the billing address in health space does show up on the left column of the license.
On the PDF.
I don't think you're gonna have people want their personal address in the back of a door somewhere.
Right. That's why people ask if they could cross it off, and I was like, yeah, that's fine. But technically, it would be against this
Right.
this provision right here.
We can just talk to Brian and licensing and just say we don't want the billing address to show up.
Okay.
The physical location address needs to be on there,
Sure.
but the billing address doesn't need to be on the license.
Yep. Okay.
isn't this sort of the same thing with the rec ed camps?
Kind of. Yeah. Yeah. Similar to that, where they wanted their well, that was their physical location. They wanted their address, hidden. Ultimately, this is all public record, so someone could, if they really wanted to know who's the address of this licensee, they could find it out. But just in a general fashion, these people don't want their home address advertised, and I don't necessarily disagree with them. But we may be able to fix that here. Okay. Matt McKay, there's a couple questions coming in.
Go ahead.
Yeah, go ahead. What are you not following?
I had submitted a question
Oh.
that was just kind of like, so for in the event that someone gets a operation without a license fee and or multiple fees, late fees, all these other things, what happens if they just pay the fee? Are they allowed to continue to operate?
I'm not understanding what you're asking.
So I think someone else had a question as well, like what happens if they, like there is, like what is the end consequence if someone continues to operate without a license?
Oh, we'll get to that in when we talk about enforcement, but generally
Okay.
what happens is if it's a state facility, we work with the county to have the DA then prosecute through the court system for them operating without a license.
Okay, I think knowing that it's addressed later on, I think answers the question. I just didn't know if that was part of that section we were working on or a further part. Thank you.
Yeah, and when it's in an agent area, they would work directly with their corporation counsel. Then it becomes, more of a civil case. Where, we try to resolve that through just fees. But if they ignore, the department or its agent, then it goes to, a civil or criminal issue, through the court system.
Perfect.
And
Thank you.
the judge can issue an injunction that basically says if you continue to operate, there could be jail time. Or,
Understood.
yep.
Thank you.
Mhm.
Oh, I'm sorry, I'm talking on mute here. That's why no one was responding. Matt McKay, your question about not sure I follow, was that in response to Chrissy's question or the defacing of a license?
No, sorry, that was my bad. I thought I got a text. I got too many computers going here, so
Oh, okay.
my bad. You could just ignore that.
You're not giving your full attention. All right. 72.08 department fees. Number 1, fee schedule. Pursuant to 97.605.1 character, no license may be issued until all applicable fees have been paid. Fee amounts listed in table A or B apply to lodging facility licenses issued by the department under this chapter. Note, local health departments that are agents for the department have authority pursuant to 97.615.2D to establish and collect fees for licenses issued by the department or issued by the local health department. If your establishment is under the jurisdiction of a local health department, contact the local health department for its license fee schedule. Offhand, for Jim or Reed, is there a way for someone of the public to go on our website and find out where the agent counties are? I know we have the map on SharePoint, but is there a way someone can just find this out?
Ted, I think it's posted somewhere on our webpage on DATCAP.
Is it? Okay.
Yep.
Maybe
Or
a
they
link.
could just, or they would just contact licensing and licensing would direct them.
Okay, yeah, true. They would. Okay. Now I'm confused where I am. Am I on B?
Types of fees.
Types of fees, thank you. A, pre-inspection fee. The operator shall pay the applicable pre-inspection fee listed in table A or B to the department before a new license is issued pursuant to 72.071B. B, license fee. The operator of a lodging facility shall pay the applicable license fee listed in 72.08 table A or B to the department for each lodging facility for which the operator applies for a new or renewal license. C, late fee. If the license fee for a license renewal is not paid on or filed before the expiration date of the license, the operator of the lodging facility shall pay to the department a late fee as specified in table A or B pursuant to statute 93.215B in addition to the renewal license fee. D, reinspection or administrative follow-up fee. If the department conducts a reinspection or an administrative follow-up of a lodging facility under or pursuant to 72.091B1 or 4, the operator shall pay to the department the applicable reinspection or administrative follow-up fee listed in table A or B. The department shall assess an additional fee as listed in table A or B, whichever is applicable, for any second or subsequent reinspection or administrative follow-up conducted pursuant to 72091B4.
That in the beginning of 4, you can strike out under.
Okay, yeah, that one tripped me up there. Do we mention the administrative follow-up and what that is anywhere?
I
Is this
believe
essentially your desk audit?
I
Or,
believe we defined it in our definitions. If not, we should.
yeah, I don't think we did. This would be essentially someone submits
This
paperwork
is-
for like a missing
Or
water
with the
test or
use,
something.
with the use of technology, they send a picture.
Okay. To show compliance with a previously written issue.
It's an alternate way of compliance that doesn't necessarily require a physical visit.
Is it a reduced fee?
It's the same fee.
Oh. I'll just make the inspector come out then. Fine, we do not define it, so.
Okay.
Okay, then this again.
If we didn't define reinspection, we should do that too.
I don't think we did either. Can the same be
Just-
said for for pre-inspection?
We could do that as well.
Okay.
I mean, it doesn't hurt. It just
Sure.
provides more clarity.
Okay, sorry, fees for operating without a license. If a lodging facility is found to be operating without a license, the operator shall pay to the department an amount of $749 in addition to all applicable fees and any processing charges pursuant to sub 3. Do those fees ever change? The operating without a license, the reprint of a license, anything of that? Is that subject to changes in this rewrite, Jim?
Yes.
It
Yep.
is. Okay.
Yeah, the reinspection and administrative follow-up fees will probably change. Will probably become lower so that it's annualized across all types of re-inspections and follow-ups.
Okay.
It just makes it easier. Otherwise, it just gets very complicated to track all that.
Note, anyone operating a lodging facility without a license is also subject to penalties in 97.72 and 97.73. Jim, do you know
Chrissy,
offhand what those are?
Yes, that gets to Chrissy's
Okay.
point about what happens if I just continue to operate without a license. 97, 72 and 97, 73 talk about injunctions and additional penalties that would be levied, through the court system.
Okay. F, duplicate license. If an operator requests a duplicate license, the operator shall pay the department a fee of $15. And I think Linda is asking a question. Should we be putting department or agent?
No, because the agents set their own fees. So
Okay,
this is the department's fees.
got it. They may adopt the same, but they may have
They
something
may not,
different.
right?
Yep. G, fee for special condition inspections. For inspection or consultation activities that are not directly related to the department's licensing responsibilities for issuing licenses, the department shall charge the operator or the entity requesting the inspection or consultation $175. Note an example includes a buyer that wants an inspection or consultation prior to a real estate transaction. Three, penalties for insufficiency of payment. If the payment of the new or renewal license is by check or other draft drawn upon in an account containing insufficient funds, the applicant or operator shall, within 15 days after receipt of notice from the department of the insufficiency, pay all applicable fees under subsection 1 and the financial institution's processing charges by cashier's check or other certified draft or money order. All right. So that takes us to the conclusion of the language. This would then take us into the table A and B. Here's currently what we have for table A and B. We don't have any new numbers to present today. But what I had alluded to before is I think our intent is to expand upon the maximum of 200 rooms for a hotel motel for these larger resorts that do have 4, 5, 6, 800 rooms. And then possibly with tourist rooming house to expand that to have, one tourist rooming house, 2 to 5, 6 to 10, whatever it may be, in the same fashion that the hotel has, so that there's a greater gradient of licenses for tourist rooming houses. And I think that will kind of address the concerns that Amy had brought up about how in her area she's got multiple facilities that have a hotel license, but really they should be getting this gradient of tourist rooming house licenses. So I think that's kind of the direction we're moving forward. Jim, gonna kind of put you on the spot, but could you speak to how the department, and maybe you can use 76 and 78 for examples, how we come up with new fees, or what's the process? Obviously, these have not been updated since 2010 and 2012. It looks like for the last time these fees were touched. But if you could provide just a little background on how these numbers are determined.
Yep. So what I do is I sit down and look at the entire cost for our program for what it takes us to do the work. Inspection staff, the specialists, the licensing, compliance, all of those portions go into the total amount that it costs us to run the program. Then I actually go through and I run a time study and how much time we're spending in each of these facilities for all the licensed facilities in the state. And then I correlate that down to retail and retail food establishments comprise the biggest part of our budget. We spend 66% of our time doing retail food establishments. So retail facilities are responsible for 66% of that budget. And I do the same for all the other programs. And, I can't remember what it is off the top of my head for lodging. I seem to think it's like 22%. So they're responsible for 22% of that budget. So I take that budget, I take 22% of that, and that's the amount at the end of the day that we have to come up with for what it takes us to manage the licensing program for lodging. And then that's what we set the fees on. And usually I will come up with 2 to 3 different licensing models. We present that to the group, we have discussion, and to me, it doesn't matter what it looks like at the end of the day, as long as we kind of hit that magic number. So we have a lot of flexibility on where we appropriate the licensing fees. But at the end of the day, based upon the number of types of facilities in that specific category, the license fee charged, at the end of the day, it has to cover the cost of that program. And then we build in a table B, which is 2 years down the road, which includes a 4% increase to help offset, inflation. And so then that usually gets us, down the road 5, 6, 7 years again before we're able to open up the rule and address it again. But that's kind of how we come up with the schedule. I start off basing it on how much time does it take in these facilities, and I assign a license fee based upon the amount of time that it takes, and then I kind of tweak that to come up to that final number. And then I'll come up with 3 or 4 or 2 or 3 different scenarios with where we think the license fees can be applied. And then you guys can provide feedback on that, or we can do some additional tweaking. But we try to do, offer different scenarios. Nobody likes to have a fee increase. I don't like to have a fee increase when my bills go up. But fee increases are, a fact of life. We have to cover the cost for maintaining the program. We're not adding additional staff. This is really just maintaining status quo. And so that's kind of where we're at. And I don't have, I have all of the numbers. I just haven't started figuring out how to apply this yet until we actually figure out kind of a model on moving forward.
Okay, thank you.
Yep.
And then just to confirm, these tables, these fees are DACAP issued licenses.
Right.
And the agent workforce will have different fee numbers. So just to clarify that point. With that being said, that is all that I have for content. Is there any open-ended questions or things from the group to be covered? If not, as I had mentioned before, December is canceled, so we will be meeting again. I believe it's January 30th is that last Tuesday of the month. So we will check back then. All right.
Thanks, Ted. Nice
You're
job.
welcome. Yep.
Thanks everyone for your
Thank
comments. And
you.
Thank
have a
you.
great- have a great
Thank you, guys.
Christmas.
Take care. Thank you.